So the cases we refer to here are first Illick versus Calgary Sun, and this was a more or less frivolous claim of abuse of process, but they pursued it nonetheless. So the only evidence they provide was that Illick sought support from other Serbians and didn't like the newspaper's criticisms of Yugoslavia. So the claim was deficient in the fact that it did not allege either an act or threat to advance an improper purpose, nor do they allege any act beyond financial contribution. So seeking financial contribution is not an overt act enough to provide evidence for their improper purpose. Here, Harris versus GlaxoSmithKline, 2010. The plaintiffs were part of a class action suit who were suing GlaxoSmithKline for suing the generic provider of Paxil, and they stated that it was a sham litigation in order to keep the generic drug off the market for another 4 years. The court determined that the plaintiff did have standing, despite the fact that they weren't the ones that GlaxoSmithKline initially sued. But they also determined that the actions GlaxoSmithKline brought against the generic drug maker were not illegal. This is an interesting distinction because it's not part of the test for abuse of power. It's the proceedings can be entirely legal. The test has to do with other considerations. They also state that even if the company had bad intentions in bringing its notice of compliance proceedings, it could not be held liable for employing a regular legal process to its proper conclusion. And that's kind of difficult to swallow compared to the test above, because bad intentions in bringing the notice, I suppose they're just saying if it was abusive process, they can't be held liable for following through on their abusive process, which took 4 years. And lastly, they said that it wasn't abusive process because there was no overt act. And this sort of challenges the test as well, because presumably the lawyers at GlaxoSmithKline know the tort of abusive process and know enough to not make an overt act. So they're perfectly able to abuse the process, as long as they don't provide anyone with evidence of their improper purpose. So, Rocky Mountain Rail Society versus HD Hobby Distribution Limited. The court in this case said, based on my analysis of the case law, 2 elements must be pleaded, and this is a simplification of the test above. First, there must be improper purpose, which is outside the ambit of litigation. Secondly, there must be a definite act or threat of furtherance of that purpose. If one or both of these elements is absent, then it is beyond the doubt that the counterclaim is doomed for failure. And that is the tort of abuse of process. Moving on to intentional infliction of nervous shock, the policy consideration here is to protect people from violent shocks to their nervous system. What is it? It's an act or statement calculated to produce harm, which does create psychological harm to the plaintiff. And the tort combines elements of derived from the writ of trespass and trespass on the case. Trespass in the sense that it must be intentional, and trespassing case in the sense that the causation can be indirect. The burden to prove all the elements is on the plaintiff, and actual damage is required, as we saw in abusive process and malicious prosecution. So, what does the plaintiff need to prove? They need to prove that there was an act or a statement. So this encompasses both statements and actions. It can be made to the person or indirectly through other people, though there was one case where it wasn't found to be intentional infliction of emotional distress because it wasn't made directly to the person. However, not all unpleasant conduct is actionable. So mere insults are not necessarily actionable. And the quality and conduct may sometimes be determined in the context or the relationship between the parties. So in Nolan, we saw the police treating someone who they had falsely imprisoned poorly and using certain racist comments. And in that context where it is a regulated profession, and there are, they do have a duty to the people that they arrest, there might be a higher standard of what is appropriate, or what is an act or a statement that could be considered to have been calculated to produce harm. Anyway, also the act or statement may be an individual act, or it may be a cumulative cause of mental distress. So beyond that, it must be calculated to produce harm. They must have intended for the plaintiff's psychological well-being to be compromised. Now, in some cases, the intent to produce harm can be inferred or imputed by the seriousness of the defendant's conduct, or by the fact that it was substantially likely to occur. So intent to inflict mental distress may also be inferred by the extent and duration of the harassment. And as with other intentional torts, it doesn't matter whether you can foresee the injuries that you cause, you are responsible for them. And lastly, harm. So this is a difficult one to prove, because the harm must be, you must have a physical or psychological illness as a result. So mere insult or sadness or hurt feelings are not actionable. So the court tests this by making sure that the plaintiff's reactions are reasonable, and reasonableness is objectively determined, and without proof of emotional distress, then it's not, this tort is not actionable. Now, with regards to particularly sensitive victims, they are not, they don't get a lesser burden of proof, or a lesser burden to prove harm, unless the defendant knew about their particularly sensitive character. So, an act or statement calculated to produce harm, which does indeed produce harm. So in the case law, 1897 was the origination of this tort, the Wilkinson and Downton case, and the judge basically just decided that these types of actions need to be punished. Prior to that, there was no case law or common law that meant if you caused emotional distress, then you had to compensate the victim. And he just determined that this is the way it should be. So in this case, there was a prank call to a wife telling her that her husband was hit by a car and had both legs broken, and she suffered physical illness as a result. So she recovered damages for the emotional distress, and also for sending someone by train to pick up her husband. Now, the judge in this case distinguished it from the two earlier cases, Victorian Railways Commissioner in Quiltus versus Quiltus in 1888. And in this case, it was a negligent act that caused the fright, and the damages weren't recoverable. And in Allsap, it was slander regarding the chastity of a married woman that where the damages weren't recoverable. So in this case, though it was indirect, it wasn't negligent and it wasn't slander. I suppose slander isn't severe enough and negligence is too remote, but prank calling a wife, I guess directly in this case, was enough for the damages to be recoverable. So 1937, Purdy and Wozniacki, the judge can impute the intent to cause the mental distress if it was likely to occur. In this case, the defendant punched the plaintiff's husband in the head and knocked him out at a bar, and the judge determined that it's substantially likely that that is going to cause emotional distress for the wife who was standing quite near them, and thus the judge imputed the intent to cause emotional distress from the fact that he should have known. In Belitsky versus Obadiak, this is another example of imputed intent. The rumors spread by the defendant reached the mother of the person who was rumored to have hung himself. So the defendant spread rumors that someone hung himself, and it reached the mother. The mother became physically ill when she found out, and the court determined that it was substantially likely that the rumors would reach the mother, and thus the defendant probably intended to cause her the emotional harm. In Bunyan and Jordan, this is an interesting case from Australia where the plaintiff suffered emotional illness when a coworker produced a gun and made vague claims about shooting someone. So she went into work, and there was a guy who with another girl, and they had been drinking. They both worked there. The guy seemed a little crazy. He had a gun, and he said, "I'm going to shoot someone tonight." Though it sounded as if he was sort of like drunk and sitting in a chair and not overly energetic. And the plaintiff went outside, and the defendant did shoot the gun inside. However, the court determined that the statement, "I'm going to shoot someone tonight," wasn't directed at the plaintiff, and thus not calculated to produce harm, and thus not actionable. And I suppose that makes sense. The fact that if you are really depressed and carrying a gun, and you're ignoring the people around you, and the people around you get scared, well, that's a different case than trying to produce emotional distress in someone else. So, Rodovsky's versus Stevenson versus Basham, 1922 in New Zealand. Here's another example of where the words were not directly spoken to the person, but they were actionable nonetheless. The defendant came into someone's house and threatened them and told the homeowner to leave or they would be thrown out. The wife of the person they were talking to was in the other room and overheard the conversation. She was sick and she was pregnant, and she had a miscarriage. And she received compensation through imputed intent in that case. Though I'm not exactly sure what the judges were thinking, it certainly doesn't pass the test from above, in the sense that the people who came into the house obviously didn't know about the fact that she was in the other room, so how could they calculate the damage, or calculate to produce her emotional distress? Rodovsky's versus Tom, 1957. Parents are attempting to recover damages after their 5-year-old was raped. This is an example of the first two elements being satisfied. So there was an accurate statement, it was calculated to produce harm. However, the parents didn't provide any proof of medical records, and thus no damages were allowed. And here, as we get to the more modern times, we're starting to discuss proof regarding the harm in this tort. So Sam and Eccles in 1961, this is with regards to imputed intent by doing the act repeatedly and injuriously. The defendant in this case repeatedly propositioned a married woman and called her at night, and anyway, they found that the actions or the damages were recoverable. And they suggested the test of Did they purposely act to inflict the emotional distress, and would a reasonable person have emotional stress as a result, replacing the proving harm element? But that was ignored by the courts as time went on. They do note in this case, though, and it's interesting that courts will go to great lengths to punish grossly wrong conduct and even allow questionable success in other torts to give damages for emotional distress. So if there's an assault that goes along with the intentional infliction of emotional distress, they can't prove the intentional infliction of emotional distress, but it's easy to prove the assault. But the assault is questionable, though easier to prove. They may let the assault slide, or they may allow the action to be successful on assault in order to provide compensation for the emotional distress of grossly wrong conduct. So Sapinka versus Sapinka. This was a case of an ex-wife suing the new wife after she lawfully chose to dispose of the remains of her dead husband's son. So a woman's ex-husband's son, possibly her son, his remains were disposed of by the new wife after the husband died, and she didn't tell the other wife. And anyway, there was no evidence of emotional suffering beyond, sadness, and so there were no damages. In Davenport versus Miller in 1990, the court awarded $1,000 damages for pain and suffering, fear and inconvenience suffered by the plaintiff in an incident in which her husband's former wife and some others sheared her hair, and presumably there was a battery that went along with this. But it does sort of start to set the limits regarding intentional infliction of emotion within a family, because within a family, the tort of intentional infliction, of nervous shock doesn't apply. But a husband's former wife, apparently it does. So Louis versus Lastman in 2001, the act must be extreme, outrageous, flagrant, or beyond mere insult, and must actually cause harm consisting of a recognized psychiatric illness and not merely mental distress. And this takes the harm element to a new, stricter level, though it's not, I'm not sure if that is still the test now. I think it's probably still debatable. The plaintiff had not alleged any acts or statements on the part of the defendant that could fit within that description or that were calculated to harm her, and had not alleged any resulting psychiatric illness. And so it wasn't actionable. In Perez Ferreira and Ayot, this was a workplace battery where an employer forcefully pushed an employee, along with some other kind of rude comments and poor feedback, etc. And this did lead to a successful intentional infliction of nervous shock claim. The trial judge awarded $45,000 in intentional infliction of nervous shock. However, on appeal, that was changed. She was still awarded damages, but they were mostly for lost work and battery. And the trial judge, as opposed to seeing the emotional distress as arising from the battery, and not, as opposed to seeing it as arising from battery, they saw it as